Welcome back to another video. In the previous two videos, we've looked at the distinction between personal rights and proprietary rights, so rights in personam and rights in rem, and we've also looked at the distinction between legal and equitable interests. So this has built a solid foundation which now allows us to start exploring the unregistered land regime. So there are two parallel regimes of land law operating in England and Wales. Now the first and most and probably more important regime governs the freehold and leasehold estates in land which are registered with the land registry. Now the land registry lists all the freehold and leasehold estates over land in England and Wales along with the current owner of that estate. The second regime, and our focus for this video, governs estates in land which are not registered with the land registry. Now, in the present day, around 95% of estates in land are registered. So this is why I say the registered regime is more important. Now, this figure is gradually increasing due to voluntary and compulsory registration rules. Within the next few years, every dealing with land will involve a registered estate and the unregistered regime will be redundant. Okay. Compulsory registration of an unregistered estate in land can be triggered by a number of transactions listed in the Land Registration Act 2002 in section 4. The most important of these transaction triggers is the transfer of an unregistered estate. So for example, if I sell my unregistered house, there is a legal obligation for the new owner of the freehold to register it. You know, whatever happens, if I claim that land, even if someone, for example, gives me their unregistered land, I have then got to register that property. So that's why over time there will be no more unregistered estates. But for now, there is a residual need to understand the unregistered regime. Okay, so unregistered estates in land. Unregistered land means that the land's title, the freehold or the leasehold, is established from old-fashioned title deeds rather than from being listed on the register. So the title is determined by looking at the conveyancing history, but just because the title of land is not registered does not mean that other rights affecting the land are unregistered. And these are the sort of things that we're going to be looking at. But in this particular video, in further videos, we'll dive into a little bit more depth into these sorts of ideas, but in this particular video, we're going to be looking at how you can establish title to an unregistered estate. So the significance of the land registry. Under the registered regime, title to an estate is constituted by the formal record of the land registry. In other words, registration as a proprietor of an estate in the land registry is the exclusive source of title to that estate. So if your name is on the land registry, then you are the owner of that estate and land. But how is title to an estate established when there is no public record of estate ownership? So with an unregistered land, there is no sort of written down place where you can see who is the owner of this land. So how can I, for an unregistered estate, determine who is the owner of that estate? So this brings us on to the idea of possession. Now, title to an unregistered estate is founded upon unchallenged possession. Possession is a conclusion of law defining the nature and status of a particular relationship of control by a person over land. According to Mabo and Queensland, 1992. And Gray and Gray, in his book Elements of Land Law, says that possession is simply a state of overall territorial control. So, if I'm honest, these definitions are a little bit wishy-washy. At best, there isn't really no definitive definition of possession. But what this is really saying is that if you have territorial control, you have possession. And if you have possession, there stems ownership, title to an unregistered estate. It's not a great definition and it's pretty basic, but that is the definition that case law and academics have set. So factual possession and the intent to possess. Now, Possession comprises physical and a mental component. So possession can be deconstructed into these two elements. Possession can be established only by a person who is both in factual control of the land, so that's the physical aspect, and by a person who intends to possess the land, and that is the mental component of possession. So let's look at both of these in turn. Factual possession. Now, factual possession depends on evidence that the claimant has asserted a complete and exclusive physical control over the land. Okay, that's from Buckinghamshire County Council and Warren 1990. The claimant must demonstrate that they and they alone have been dealing with the land as an occupying owner would be expected to deal with it. And an essential element of factual possession is control over the access of strangers to the land and their activities on the land. Now, a good case to look at is J.A. Pye Limited and Graham from 2003. In this case, J.A. Pye granted Graham a license to use part of its land for agricultural purposes. The license expired. Graham repeatedly asked for renewal and the company repeatedly refused. But Graham just continued to use the land as he had been previously. So despite not having this renewed license, he continued to use the land as he had been doing so previously, during which time it was accessible only through a gate, which Graham kept padlocked. So Graham had control over the land. Now the House of Lords were very comfortable in concluding that Graham had a factual possession of the land. He had complete and exclusive control of the land, demonstrated by the padlocked gate. There's also, of course, a second element, which is intent to possess. So a successful possession claim requires not only complete and exclusive control in fact, but also an intention on the part of the claimant to have such control. There must be evidence of intention in one's own name and on one's own behalf to exclude the world at large so far as reasonably practical and so far as the processes of the law will allow. This intent to possess can often be inferred from the claimant's factual possession. So in practice, if a claimant claims they factually possess land, it would be pretty easy for them to prove that they intend to do so too. It's hard to imagine a scenario where factual and mental possession are disjointed. I mean, try to think of a situation where someone's physically on a piece of land, but they don't intend to physically possess that land. It's difficult to think of such a situation where that would be the case. So, arguably, you don't necessarily need to even determine both parts of the law. Maybe you just need to determine the factual the factual possession of the land, and the intention will just come as a result of that. But still, the law technically does say that you need to prove both factual and intentional possession. The key determinant of estate ownership under the unregistered regime is the behaviour consciously adopted by the claimant. A claimant who behaves as if they own land satisfies both the physical and mental elements of possession, and in the absence of a stronger claim to possession, is entitled to an estate in land. So as I'll see in a bit, we'll have a little bit more of a look into this. Okay, so for example, someone who behaves like they own land will actually satisfy the physical and mental elements, and from this will stem the ownership of land. So, as Gray says, estate ownership is a self-defining phenomenon. Of title. In theory, possession is an absolute concept. Either X is in possession of land or he is not. So if he is in complete and unchallenged control of a plot of land and he intends to have such control, then he is the possessor of the land. And if he is not the possessor of the land. But in recent years, there has been a judicial dilution of the traditional understanding of possession. In some cases, possessory remedies have been extended to those who unquestionably do not have overall territorial control of the land. So in Manchester Airport and Dutton in 2000, a company had been given a contractual license to enter land to prepare a site ready for the construction of a second runway. But in advance of them entering the land, they were granted a possession order which entitled them to remove environmental protesters from the land. So although the contractors hadn't factually or intentionally possessed the land, it was held that they had a greater claim to possession than mere environmental protesters who had no contractual right to be on the land. So they were allowed a remedy, usually to those who own the land. They could sue in trespass and remove the protesters. So this case has diluted our traditional understanding of possession. A traditional approach would have meant the contractors could not sue the trespassers, as they do not have any physical control over the land, and no intention to have such control. But the Court of Appeal said differently here. Okay. And this dilution has introduced a relativity in the concept of possession, and consequently a relativity in the concept of title to unregistered estates in land. So in the Manchester Airport case, the conclusion was that the contractors had a better right to possession than the trespassers, and if they have a better right to possession, despite not having overall control, they are entitled to possessory remedies. Now, the person with the strongest claim to possession is the person with the best title to an unregistered estate in land. So this all means that ownership in unregistered land is all down to who has the best claim for possession. So historically, a vendor's physical possession of land would be the only evidence of their title to the freehold. Possession, and therefore title, was conveyed from seller to a purchaser by a symbolic act performed on the land, e.g. handing over a twig or sod of earth in the presence of witnesses. In the modern day, a purchaser of unregistered land still needs to judge whether the seller has good title to the freehold and that it is safe for them to pass on the title. But visible possession of land is not the only evidence of this. It's not the only evidence of the title. Evidence also lies in the chain of documentary records, the title deeds, detailing previous transactions with the land. So the purchaser of unregistered land must look for a root of title and would not just look for the physical possession. They need to see a root of title. Both evidence of possession and good root of title will make me and a buyer fairly certain of their ownership. So although historically it was just focused on the actual physical possession of the land, nowadays it's the physical possession plus a good root of title, which we'll look at in a second. So the purchaser, so when it comes to verifying a seller's title, there's the title deeds. Now the purchaser uses the title deeds in order to establish an unbroken chain of ownership to the present seller. This unbroken chain, when coupled with the seller's undisturbed possession, serves to establish the seller's superior rights to the freehold estate. Okay, so this leads us on to the root of title. Now, the root of title is the most recent conveyance of land occurring at least 15 years prior to the date of the proposed sale, and from which there is an unbroken chain of ownership to the present seller. Now, the purchaser's main preoccupation is determining the root of title when it comes to unregistered land. The purchaser wants to find a conveyance from which they can track an unbroken chain of ownership after the present seller. So, for example, if I buy land in, let's say just 2020, so this year, for example, and find that the previous transactions are from A to B in 2005, B to C in 2002, and C to D in 1986. Now, the transaction between C and D in 1986 is the vendor's root of title, and the subsequent transactions A to B and B to C up to the current transaction this year in 2020 is the unbroken chain necessary to establish the vendor has good title and can therefore sell the property. If they can find a good root of title that they can rely on, that is a proof of ownership, and therefore that transaction can go through and that'll be fine. So the root of title relevant to the purchaser of an unregistered estate in, let's say, 2019 is the first conveyance executed prior to 2000 and doing some math in my head, 2004. Okay, it's got to be 15 years of, or I could say 2005, 2004, depending on what part of 2015, but 2005 would be about right. So it's got to be 15 years. So the Law of Property Act 1969 made it easy to determine good root of title by reducing the number of years that needs to be examined prior to the current date from 30 years pre-1970 to 15 years today. Now, a purchaser can rely on the root of title as proof of ownership, even if there is some defect in title prior to the root. So the root of title needs to be found for unregistered land today to prove the quality of that ownership. However, after this sale, the owner must apply for the first registration of title under Section 4 of the Land Registration Act 2002. So having to establish root of title is becoming less frequent. Now, this video was very much focused on how to establish title to unregistered property, and you can see how it's a little bit more complicated than just looking at the land registry compared to registered land. And the real focus for finding title is looking at the root of title, as we've just discussed here. In the next video, I will be continuing our discussion of unregistered land and specifically looking at the effects of rights in rem on third parties. Thank you very much for watching. If you have any questions at all, please leave a comment below and don't forget to subscribe to my channel. Thank you very much.